guest speaker, Ms. Divya Chavan, who will be conducting a lecture on procedural aspects of sexual harassment of women at workplace, Prevention, Prohibition and Redressal Act 2013. Currently practicing at District and Sessions Court, Pune and Family Court, ma'am handles matters that are involved with civil laws, family laws, and criminal laws in particular, matters that are related to atrocities against women and child abuse. Ma'am has co-founded Gender Sense, which assists in establishing and advising of the setup of in-house mechanism to deal with protection of sexual harassment of women. Ma'am has been actively working towards the protection of women as well as fighting for justice for those who have been abused or violated. She also has been actively contributing in the development of the legal fraternity through various publications and research papers in renowned journals. Thank you so much, ma'am, for joining us today. With that said, all the participants are requested to keep their video off and restrain from unmuting themselves. The chat box will be live at all times, so do put down your queries, which will be addressed by the speaker at the end of the lecture. Do keep a pen and a notepad with you handy to keep information and jot them down during the session. Without any further delay, I would request ma'am to take over and commence the session.
Thank you, Priya. Thank you, Law Cure, for inviting me for this lecture and to involve me in spreading legal awareness among students, professionals, and everybody within the society. This is a great initiative, and because legal empowerment is required and is the need of the hour, because people need to know what the law is and need to know how it plays out within the society. So thank you, Law Cure, once again for inviting me. Today we would be discussing on this very, very important issue and this topic called sexual harassment at workplace. I'm sure that we all have been reading about it in the newspapers. We have been also raising voices. I'm sure all the law professionals here will be very, very will know about this issue and about this topic on sexual harassment. But what exactly are the nuances of the law? Why did it play out? I think it's very essential for us as lawmakers or those who are practicing law to really understand this law in its entirety, so that when any issue comes before us, we are able to handle it in a proper manner. So let us go today on discussing this law and this topic on prevention of sexual harassment at workplace. There is a small PPT which I would like to just share with you all, so that we can just go through the different sections and different concepts which are there in the law. And I would appreciate if all of you all also would ask questions, because I'm sure I would like to answer all the questions and all the queries. So after the PPT, which I'll quickly go through, then I would appreciate if you all ask me the questions and I'll happy to answer them. Yeah, so can we just share the PPT there? Or should I share it from my end?
Ma'am, it is being shared.
Okay. Great. So just to start off, you can see the first slide called Gender Sense. So when this law came out in 2013, not many people knew about this issue or what is exactly sexual harassment. Therefore, me and my colleague, we started something called Gender Sense, where we imparted education and training to various places with respect to prevention of sexual harassment of women at workplace. So with that initiative, this Gender Sense was born, and therefore we try to reach out to people with certain training objectives, which you will see in the next slide, which are basically the training objectives would be, imparting or creating awareness amongst all here, of course, IC members, but everybody here today on all aspects of sexual harassment, to also understand how IC members, what are IC members, who are IC members, and how their role, what is their role exactly in, the making a decision when it comes to sexual harassment, and to familiarize everyone today. Of course, this PPT is mostly for IC members, but I'll be sharing this with you all today to discuss on what are the legalities for the effective functioning of an IC. So today, those are the training objectives which we would be touching on. But before we also go into the details of the law, we would, as you may see in the next couple of, in the next slide after this, that, what exactly, why did this law actually came into place in 2013? So, of course, we all are aware of the Me Too movement, which had created a stir not only in India but the entire world, and it's still women are speaking up with this hashtag and voicing their concerns on sexual harassment. But this did not happen very recently as Me Too, but it happened way before. In fact, if you see on the next slide, in the 80s, in fact, when there were more and more women who joined the workforce, there were various forms of discrimination which they were facing, not only in India but all over the world. And in fact, all countries came together and they had a convention on elimination of all forms of discrimination against women, which is popularly known as CEDAW. I'm sure we in our law school must have gone through this convention sometime or the other. And India ratified this in way back in 1993. Where we were supposed to make laws and various legislations with respect to women, to ensure that they are protected and all forms of discrimination are prevented against women. So ideally, laws were supposed to come in picture and enforce way back, right, since 1993. But unfortunately, there were various incidents happening, and not many laws as such were being passed. There were still laws which were passed, not with respect for women. Not many laws were passed, but unfortunate incidents went on happening. As and when women started joining the workforce, they faced a lot of discrimination. And one such woman was a lady called Vanwari Devi. This lady, in fact, she faced a lot of discrimination, uh, where she was in fact raped. Such to such extent, this discrimination is what she faced. So this happened in the state of Rajasthan, where she was working for the government of Rajasthan to abolish child marriages. Now, when she was working with the government, there were a group of men uh, who uh, who decided to teach her a lesson. Why? One, because she was a lady of a lower caste. Second, because she was working to abolish child marriages, and third, because she was a lady and she actually dared out to go and work. Therefore, they wanted to teach her a extremely harsh lesson, and therefore they gang raped her. This outraged the entire country, and there was an NGO called Vishakha who actually filed a PIL before the Supreme Court of India in 1997, stating, not in 1997, way before that, in the early 90s, stating that women in the country are not safe, especially at the workplace. Not only did this there was this PIL which was filed, but there were various other PILs which were filed before the Supreme Court. And the Supreme Court also realized the urgency and the seriousness of this matter, wherein they recognized that women at workplace are not safe, and sexual harassment was actually something which discrimination which women were facing at workplace. And therefore the Supreme Court for the first time actually defined what is sexual harassment and passed certain guidelines.
And you can take a look at it.
Yeah. and passed certain guidelines way back in 1997. And according to these guidelines, it was the employer was supposed to ensure that women at their workplace were safe, etc. But what happened? The guidelines just remained guidelines, and nothing really. They were just on paper, and not too many people knew about it. And it only happened, in fact, then there was a bill which was pending before the legislation, but it only happened after the Nirbhaya case, where there was a Criminal Law Amendment Act which was brought about in 2013. Also, this law on sexual harassment of women at workplace was passed in 2013, and also protection of children against sexual violence, sexual offences, POXO, to 2012 was also passed. So all these new legislations came up in 2012, 2013, and this 2013 legislation actually took, considered all these guidelines and incorporated and looked at the guidelines and incorporated it in the new legislation. Thereafter, so this was why exactly this law came into place. In fact, today at various places, I will be talking about it also, that there's a redressal mechanism in this 2013 law, which is the internal committee or the internal complaints committee. So in fact, till today, people refer this committee as the Vishakha committee because of these guidelines, because of the Vishakha guidelines, which were passed in 1997. So this was a little history of the law. If you go to the next slide, in fact, if this law, or even in fact these guidelines, it was required that they were passed because the impact of sexual harassment was extremely severe. Not only victims had lower efficiency, they resented socializing, but they made errors at work. They skipped work more often. In fact, the overall performance of that victim suffered, uh, along with mental health and physical health. But not only the overall performance of that victim which was suffered, but even the organization or the companies where women would work, even the work performance of that organization or company impacted to a great extent, and it was affected. So therefore, it was required that this law was passed, and it was also required that all these, after giving regard to all these impacts of sexual harassment, that something needs to be done to ensure that workplaces are safe for women, to ensure that they do not have lower work efficiency and the performance of the organizations does not get affected. Further, if you just see on the next slide, uh, so basically the objective, so the name of the law is Sexual Harassment of Women at Workplace, a Prevention, a Protection and Redressal Act 2013. So let us go through the details of this law. So the main objective in this law itself, if you see the name of the law, it has the objectives engraved in the name of the law itself, which is prevention of sexual harassment of women at workplace, protection against sexual harassment, and redressal of complaints, redressal of all complaints of sexual harassment. So this is basically objective of the law. Further, if you go ahead in the next slide, you will see that the law has in fact detailed out what are the duties of the employer when it comes to the workplace. So in fact, many a times employers do not know, okay, they know what is sexual harassment, but they don't know what is to be done. So this law is extremely great to that extent that what are the duties of the employer are also listed down. So it is the duty of an employer to provide a safe working environment, to constitute an internal complaints committee, or it's also called the internal committee now, displaying the details of the committee. This is a very, very important step because many places details of the IC are not displayed. So it is in fact, it is the duty of the employer to display the details of the IC, to organize workshops, awareness programs around this topic, to initiate action if there is any form of sexual harassment, and to treat sexual harassment as a misconduct. So these are the important duties of the employer. In fact, if you see on the next slide, that if the employer does not perform this duty, there is a legal penalty of rupees 50,000. And the continued, if there is a continuation of this violation, they might even lose their license to operate. So such is the seriousness of this law, where the employer has to ensure that they follow all the compliances when it comes to this law. So this must be remembered, because if there is a continued violation, they can lose their license to operate. And in fact, it will be treated as an offense if they do not comply with the laws. Further, if you go on, see on the next slide, the effects of non-compliances are severe, especially in this day and age when we are encouraging more and more women to come into the workforce. We are ensuring that there is diversity, equity, and inclusion (DEI), which is now very popular, or which is followed by almost all the companies, all the organizations all over the world. And this is something which every company all over the world, they have to have this. They are working towards DEI, or diversity, equity, and inclusion. So if you do not have, you're not compliant with this law, it's for sure that you're not a women-friendly workplace. If there are instances of sexual harassment and if it is not addressed, then it does not, as I said, we've already seen that it has impacted the organization and the victims, but it also has lower efficiency amongst all the employees. Because if any such incident does happen, everyone just, it just becomes the gossip of that company or the organization, and nobody is able to concentrate on working properly or efficiently. And people, employees in fact start feeling that my workplace is not safe, and we are not comfortable in working in such a place. So that's what effects of non-compliances are severe. And so if you go to the next slide, you may see that it's not only non-friendly workplace, but there's a loss of brand and goodwill, loss of investor confidence, because these days each and every investor will look at all these compliances, whether or not you have a posh policy in place, whether or not you have all the details, an IC, etc. in place. So everything, the investor goes on to see all these documents. So the impact is severe on the company, even when it comes to their presence in the media, etc. So in its true spirit. If you go on to the next slide, now let us see each and every aspect or concept under this law. So let's see what do we mean by sexual harassment? What do we mean by women, our workplace, etc. But even before that, let us go first into the redressal mechanism. We've been talking about the employer has to constitute an IC, or the IC, which is an internal committee or an internal complaints committee. So let us first see exactly what does this committee actually do, or what happens if there is a complaint of sexual harassment? How does it, where does it go? What really happens? So let us see how these complaints are actually addressed. First and foremost, it is always good that, or it's a good practice if the organizations or companies have policies around POSH, or that is prevention of sexual harassment at workplace, wherein it details out that what exactly is sexual harassment, where sexual harassment is defined, what would be the inappropriate behavior which people would that this is sexual harassment, this is not sexual harassment. So what would be the relevant examples of inappropriate behavior? That also can be included in the policy. What would be the procedure in case there are complaints? And of course, even to mention that there'll be no retaliation against complainants, because many a times complainants feel scared, or they have the fear that if they go and if they complain of sexual harassment, their job can be at risk or they might be terminated, etc. So many women prefer not to go and complain. So therefore, if it is mentioned in the policy that it will not be, there will be no retaliation against the complainants, then even the complainants will have that confidence to uh, come and to tell the details of the complaint before the committee. And of course, zero tolerance to sexual harassment. So each and every organization must make it clear to their employees that there will be zero tolerance if there are any instances of sexual harassment, wherein it will be treated as a misconduct and action will be taken in such cases. So if there is a clear cut policy, so policy is not a mandatory provision where that you have to have a policy. It's not that, because there is a law in place, or and so there is a law in place, and there is a law which is already, the 2013 law is already there. But when it comes, if there is a policy, of course it is a good practice, so that even employees can go through the policy, can understand what the policy of the company is. So it's always good to have a policy. It's always good practice to have a policy. If you go on to the next slide, you may see that further, in fact, the Bombay High Court in 2016, in one of the cases, has mentioned that in fact organizations to should draw up a list of for up a list of do's and don'ts for the male employees, and that instances of misconduct against women will not be treated casually. So this was in fact, as what I was saying with regards to policies. So the same thing Bombay High Court has also mentioned in their case laws about the do's and don'ts. And also, it mustn't women must not use this law to settle scores or file false complaints against the respondent or against men. So it will always be good to draw up these list of do's and don'ts and incorporate it in the policy itself. If you go further, if you go to the next slide, you will see that every employer with 10 or more employees has to constitute an internal complaints committee or internal committee. So that means every organization, every employer. So there is, it's not like only companies have to do it or only educational institutes have to do it. In fact, every place, be it a mall, be it a hospital, just anywhere wherever there are more than 10 employees, there has to be an internal committee. Further, if you go to see, let's understand who are the members of that internal committee. Before we you can read it on the slide. Before we just go ahead with these details, I have to just take an urgent call. If you just excuse me for 30 seconds, but till then you can just.
Yes, ma'am. Yes, ma'am.
I'm sure till then I'll just quickly finish with the call and come back. So you just can read out who are the members, how the. So you can read it out, Priya, so that our audience.
Yes, ma'am. So the members of the ICC, the first is the presiding officer. It would be a woman employed at the senior level at the workplace amongst all the employees. One member should be from the NGO, that is non-governmental organization or association, committed to cause of women or familiar with the issues relating to sexual harassment. Two members must be amongst the employees committed to the cause of women or with experience in social work or having legal knowledge. And then at least one half of the total members nominated should be women.
Yeah, thank you. Priya, for discussing this with everyone. Why is this important to understand who are the members of the IC? I'm sure maybe some of us must have already read the law and read what exactly these are the members of the IC and they have to be constituted. But many in various organizations, the IC is not properly constituted, and because of that, because the constitution of the IC is not proper, because of that they can face various consequences. Maybe later, or maybe if it goes before the high court, or if it goes before the appellate body, or even right at the beginning when a woman comes to give a complaint because the IC has not been constituted properly. And now this uh, uh, so for example, the presiding officer has to be a woman. Many a times, of course, sometimes there are no women leaders, or no women women who are employed at a senior position, and therefore it becomes very difficult to appoint a presiding officer. But it is recommended, but this is the law. You have to ensure that there is a woman at a senior level. Further, two members amongst employees and one member out of the NGO or association. They also can be lawyers who can be a part of this committee. Now, this member also, many a times, companies or organizations just take somebody within their organization itself, or suppose they are an NGO itself. So all of them are social workers, so they'll just take somebody from them because from within their organization itself, because they feel that no, this is a member from an NGO. So this member is an external member. This external member cannot be from that organization or cannot be from that company. So this is for the only reason so that the IC will be a balanced body, will be a neutral body, and to ensure that there is no bias even while the IC going through the complaint or going through the entire investigation. Therefore, the lawmakers also have made sure that there is this non-biased or neutral party which is there within this committee to ensure that there is no biasness. The other thing is, the most important thing is also half of these members nominated have to be women. In practice, many a times it is seen that there is only one woman and more male members, or the entire committee is women and there is no male member. So many a times there is a lot of discrepancy. The committee is not balanced. So, though it is mentioned that half of the members have to be women, it must be. It's a good practice if you do not have all women who are members of the IC, or or only one woman and more men in the IC. It has to be a balance. There have to be a balance of both the genders within the committee. So this is with respect to the constitution of the IC. If you go on to the next slide, the constitution is of the IC is minimum 4 members, which have to be there. Many a times in practice, if you see that there are too many IC members within the IC itself. Maybe there are sometimes 7, maybe there are 10, because companies and organizations want that everybody is properly represented. So, but it is always recommended to have least number of people, because imagine if there is a complainant who has to go and who has to disclose what has happened to her. Imagine 8 people sitting in front of you, and you have to say such a thing. People are not comfortable to speak to many people. Already there are 4 members, who have to be there, who have to be a part of that committee. So it's always recommended to have a fewer number of people and not have too many members. But in practice, it does happen. Many companies, many organizations have 10, have 12 members of the IC, because they feel, okay, if some people are not there within the committee, the other people will sit for the case. But that does not happen. Everybody has to sit for all for for every hearing. So the quorum will have to be there. So it's very difficult to get so so many people on board and to hear the entire case. The tenure of the IC is 3 years. So it has to be remembered that the tenure gets over at 3 years and it has to be reconstituted. In many companies and organizations, people leave the company. The IC members, they either join some other company, and many a times companies and organizations miss filling out that gap of within the IC. So that is another thing that if y'all are a part of any IC or y'all are going to advise any ICs, ensure that y'all keep looking at the constitution of the IC to ensure that the all the people who are there within the organization are there with the IC, because many a time people keep leaving and leaving the organization, and then the IC is not a proper quorum. So if you go to the next slide, this was with respect to the constitution of the IC. I'm sure you all will be also wondering that why am I discussing so much on the constitution of the IC? Because if the IC itself is not properly constituted, and if there is a case which the IC has heard, and then if any party goes in appeal or in writ to the High Court, and if they see that the committee is only not properly constituted, then it will come back to the company or to the organization, and they may say that you have please ensure that you constitute the IC properly and hear the inquiry again, or go through the inquiry again. So it is very important that the IC is constituted, because if it is not constituted properly, again one will have to go through the entire process of inquiry. If you go to the next slide, after removal, there are certain things of how an IC member is removed. But if you see the duties of an IC, what is the duties? It is a decision making body. The IC also has the powers of a civil court to in fact take statements on oath, to examine documents or any other proofs which come before them. So as such, they have wide powers of a civil court to even summon any person before them. So such are the duties of the IC, and therefore it is very important that the IC also understands the nuances or the details of how a procedure is supposed to be conducted, or the details of this law. So the main one is a decision making body. In fact, all complaints of sexual harassment will only be heard and processed before the internal committee. Many a times in many organizations, they'll have a disciplinary committee, or they may have the HR who is taking care of all such issues. But no, if any incident of sexual harassment does take place, it is not the HR, it's not the team leader, or it is not the disciplinary committee who can go through such inquiries or can process the complaints, but it is only the IC who can hear and process complaints of sexual harassment. In practice, it is seen many a times there are small instances of sexual harassment which do take place, and it's taken care by the HR, or it's taken care by the team leader. But if they take action, and if it is not brought before the committee, and then if something goes it becomes severe, the incident in question becomes severe, then it becomes very difficult for the IC also to ensure that it is stopped, or it's become too late already to for the incidents to happen. Because so it is always better that the IC only hears any complaints of sexual harassment right at the beginning, however small or however serious it is. So it is only the IC who will hear the complaints of sexual harassment. Going further, when you speak about sexual harassment, there are a few questions which come into anybody's mind. Is that where, when, how, and by whom, and against whom can a complaint of sexual harassment can be filed? So if we quickly go through the where, when, how, and by whom, we can understand how the inquiry will actually go on. So if you go to the next slide, where of course it's the internal complaints committee, or the internal committee. But a complaint, now there you can see on the slide, there is some LC. What is LC? It's the local complaints committee, which is constituted by the state government. So wherever there are employees less than 10, so such people can go to the local complaints committee. Or if the complaint is against the employer himself, then of course IC will not be the right forum to go. So that person will have to go to the local complaints committee to lodge the complaint. In fact, if you go to see, even our domestic help or domestic workers are also included within this ambit, because even they can go and they can also file a complaint to the local complaints committee if they have been a victim of sexual harassment because of their employment status. But since but they will have to go to the local complaints committee. Next, if you see, we've taken care of where. Now, when a complaint has to be filed within last 3 months, within 3 months of the last incident. In certain cases, the IC can condone delay because if a complaint has come after 1 year, and then if the IC feels that it is important to condone delay, and if it's important to go through the entire complaint or hear this out, so in such circumstances, they can condone delay. Now, especially when the Me Too movement happened, there were many women who came forward and they filed complaints of sexual harassment which had happened with them 5 years before, 10 years before. Of course, police took cognizance of it under the IPC, but even many ICs also took cognizance of certain cases. But in such cases, they condoned the delay where they felt that that incident was deserving of being heard. So this is about when. Now, if you go to the next slide, you will see how a complaint can be filed. Now, a complaint has to be in writing. There can be an assistance from the presiding officer. Many a times, women do not want to give complaints in writing, and they just want to tell that no, this is what has happened to me, but I don't want to give anything in writing. At this time, the presiding officer or the members can play an important role in providing assistance. Uh, at many a times, even the aggrieved woman is not in a capacity to come and give a complaint. At such times, the legal aid can also come and give a complaint. Or if the complaint is made to the HR also can forward the complaint to the IC. So this is the way a complaint can be filed. Further, if you go to the next slide, how um, like I said, many women do not complain sexual harassment because of this fear, etc. So at that time, the presiding officer can come and or the member of the IC can help them note down the complaint. If you go to the next slide, uh, you may see that when a complaint actually comes before the IC, first and foremost, they have to see whether or not it is a prima facie complaint of sexual harassment. Whether it is sexual harassment, one, whether that incident happened at the workplace, two, who is the person making the complaint and against whom the complaint is made. So these are the important issues which have to be considered even before going through or considering any complaint which comes before them. So if you go to the next slide, first is whether or not it is sexual harassment. So the committee has to see whether it fits within the definition of sexual harassment. Now the law has made it extremely clear, has properly defined what is sexual harassment. It means any unwelcome acts or behavior, whether directly or by implication. It can include physical contact, advances, demand or request of sexual favors, making sexually colored remarks, etc. Further, if you go to the next slide, the definition just does not stop here, but also goes ahead saying that pornography or showing pornography will also be under the definition of sexual harassment. And any other unwelcome physical, verbal, or non-verbal conduct of sexual nature will also be sexual harassment. Many a times there are many instances of non-verbal conduct of sexual nature, where and mostly such instances cannot be actually, there is no proof or no evidence at times with this non-verbal conduct of sexual nature. women just feel that no, I just feel uncomfortable around him because they have a sixth sense, about it. But whenever such incidents of these unwelcome acts of behavior, which are non-verbal conduct of sexual nature, it is very important so that the inquiry goes ahead properly, so that there is proof. It's always good to ensure that these conducts are discussed with somebody. There is a witness to them, or even if a woman is facing such behavior, she quickly immediately reports it, so that this conduct is stopped right at the beginning itself. So all this is the definition of sexual harassment. In fact, the definition is so wide under the law. If you go on to the next slide, there are also certain quid pro quo situations which are included under the law, which includes promise of preferential treatment, threat to detrimental treatment, threat about a future or a present employment status, etc. So all such quid pro quo situations are also included within the act. And it does not stop here. In fact, if you see on the next slide, you will see that interference with her work, creating an intimidating, offensive, or disturbing environment which affects her health and safety also is included within the definition of sexual harassment. So the definition of sexual harassment is extremely wide, and therefore whenever it comes before the IC, they will ensure, or they will see the prima facie, whether or not there is a prima facie complaint of sexual harassment. And even while concluding the inquiry, they will see that whether the conduct of that person or of the respondent is such which falls within the definition of this. If it does not fall within this definition of sexual harassment, which is already very wide, then it will not be sexual harassment. Yeah. If you go to the next slide, also, again, now, concept of consent. The consent also plays an important part in all of this. But this topic itself will take me a long time to discuss, because consent itself, the nuances, the gray areas, how it plays out in different situations is a different discussion altogether. So maybe some other time we can discuss about consent. But it is important to remember that whether or not consent is there, it can be given regard to when it comes to sexual harassment. If there is no consent, then of course no is a no, and it will be treated as sexual harassment. If you go on to the next slide, there are various behaviors or instances of sexual harassment that can amount to that can be treated as a misconduct. So, like the Bombay High Court also in the case law which I spoke about earlier, in the policy also all these instances, all behaviors can be listed out. And of course, it will not be only these. This not It will not only be limited to these. It can, or even all the other incidents of sexual harassment can be included in this list. Further going to further going on the next slide, what is not sexual harassment? So it is very important to see the difference, or to draw a line between what is sexual harassment and what is not sexual harassment. So clearly, workplace disputes, misunderstandings, disciplinary issues, rude behavior, aggression, strictness will not amount to sexual harassment. Just to give you an example, in fact, I handle many complaints with respect to sexual harassment. And in one such incident, there was this lady who came, and she mentioned that she came and gave a complaint to the committee, the internal committee, and she stated that I have been, my senior called me into his cabin, and he started screaming at me, and because of which I started crying. And this harassment must you must take cognizance of this harassment. So of course, when you hear such or read such words with respect to calling in the cabin, screaming, yelling, of course, the first thing what the IC will do is call the complainant and to understand what exactly has happened. Now, when she came before the committee, we tried to understand what happened. Then she told that, no, he called me. I had not performed my job properly, but he called me in the cabin and he started screaming at me. And when he started screaming at me, everybody started staring at me, and I started crying because of that. So it was not it was an inappropriate behavior. So, but when we asked her, was it with a sexual with a sexual intent? So at that time she said, no, 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 it wasn't with a sexual intent at all. He was screaming at me. He was extremely rude. So clearly, the IC will not be a proper forum to hear this complaint. Why? Because it was not with a sexual intent. It will not fall under the definition of sexual harassment. And therefore, it will be maybe a disciplinary issue which will have to be looked into. So therefore it is very important to draw uh, to see or to make a difference between what can amount to sexual harassment and what cannot amount, what will not be sexual harassment. So clearly, workplace disputes, misunderstandings, disciplinary issues, the IC will not be the proper forum to look into. If you go to the next slide, it is very important to understand what is a workplace. So of course, goes without saying, it is your company, it is your organization. But if you go to the next slide, you will see that workplace is not only defined to your company or the four walls of the office. There is a notional extension of workplace. That means any place visited during the course of employment will be workplace. Transportation will be workplace. Digital workspaces will be workplace. Everyone was working from home. So in virtual meeting rooms, telephone calls, emails, messages. So workplace now is not just restricted to those 9 to 5 working hours. It may be restricted even beyond your working hours because digital workspaces are also there now. It also can be any place visited during the course of employment. So that's not only limited to it can be office parties, it can be conferences which the company sends you or the organization sends you. So it basically means any places which one visits during the course of employment for work, etc. Uh, so that is when it comes to workplace. If you go to the next slide, there is transport also, which is mentioned. Transportation has also been mentioned in the law. But again, now this is a gray area, whether it's public transport or private transport, because everybody goes to travel within public. But how will the IC really ensure? So again, this is to this matter of discussion. But clearly, even transportation will be included within workplace. If you go to the next slide, now by whom a complaint can be filed. So under the 2013 law, only a woman can file a complaint. So only an aggrieved woman can file a complaint of sexual harassment. Now here there is employment status no bar. Why? We will see. And if by policy, so as we have already seen that we can have organizational policies. So by a policy, any person also can be a victim of sexual harassment. So by policy, the organizations can make a policy with respect to sexual harassment to ensure that any person who is a victim of sexual harassment can file a complaint of sexual harassment uh, by policy. But again, by the 2013 law, it's only women. So only the complaints of women will go before the IC. If there are complaints of sexual harassment by a man or by a transgender, then that person will, and that too only if they are employed. Uh, the other persons will be only if they are employed with the organization. Then it will go before the disciplinary committee. But by 2013 law, it will be the women which can go before the IC, and it will be any woman. Now, who can be the woman or the victim? Who can be a person or an aggrieved woman? Now, of course, goes without saying, if she's employed with that company or organization, she can file a complaint. But even if she's a client, vendor, consultant, or even that if she's a student or an intern who is, come to that organization, So all these people, they'll be they can go and they can complain of sexual harassment. Further, if you go to see in the next, against whom a complaint can be filed. Of course, it can be filed against the respondent, that is the person against whom the complaint is made. Now, here under the law, it's just said any person can be a respondent against whom a complaint is made. It is not specified that it's a man. So goes, it can also be a woman against whom a complaint can be filed. And again, employment status no bar, but there has to be a relationship of work. For example, if the lady is an employee of the organization or the company, and that person is a vendor or a consultant, etc., and that person is sexually harassing this lady, then she can file a complaint against him. Likewise, so employment status no bar. So these are the basic questions which we have answered. If we go, so if we quickly go through the next few slides so that we just complete this portion. Next, there is just one slide which I would just like to show all of y'all how an inquiry actually takes place, and then we can end the session. Next. Next. So, yeah, the next one. So if you go to see, on basis of a prima facie case, either there can be a conciliation or there can be inquiry. Now, conciliation also can be done by a woman where she wants to amicably resolve these issues. So minor issues, whether it's misunderstandings, where she just wants, that person to stop messaging her, etc. These can go through conciliation. But when, of course, the issues are serious, or she wants to ensure that the inquiry proceeds, the committee has to go through an inquiry. Then the inquiry has to be complete next. The inquiry has to be completed within 90 days. Now, in the inquiry also, opportunity has to be given to both the parties. It's not just the complaint is given and then the decision is made only by hearing the complaint. But it has to be given to both the parties. It has to be concluded within 90 days. And at the end of the inquiry, there is a decision taken by the IC in the form of inquiry report. So all these, and once the inquiry report is given to both the parties, where they can make their representation, and then where recommendations are given. And then after that, if any party is aggrieved, they can go and appeal to the appellate authority, or then they can go in appeal to the, not in appeal, they also may go in writ petition to the High Court in deserving circumstances. So this is the entire process of the inquiry. Of course, it has to be, there are few things which are looked into. The principles of natural justice, the principles of proportionality, Wednesbury principles, all these principles are actually looked into while going through the entire inquiry and while giving a decision. So, like, if we just go to the end of the end of the PPT, we have discussed what are the different concepts and what is the inquiry process. Of course, this topic of sexual harassment is a big topic to talk about, and there are so many different issues and different things which actually go into the entire inquiry process, and they can be and even when the actions are taken, it can be right from giving a warning or a written apology, asking the respondent to giving a written apology, and it can go to right to termination. And again, the other way also, if in case there are false complaints which are filed before the committee, the person who's giving a complaint, she will get the same punishment as if it were true. So suppose if that respondent was going to be terminated, if it is found that she is given a false complaint, then she will be terminated. So leaving you with certain last thoughts, this law is a shield and not a sword. So it's important to strike a balance. It is important to formalize best practices and to ensure that there is correct awareness within the society, within organizations, and within companies. So thank you again, Law Cure, for inviting me to discuss on this important topic. If there are any questions, I will be happy to answer them and to discuss any point. And suppose if you are not able to discuss answer all the questions today and you will come up with questions later, you all can always write to me or write to Law Cure and they will forward those questions to me and I'll be happy to answer them.
Thank you so much, ma'am. The round is open for questions. If anyone has any questions, kindly put them in the chat box or you can directly ask it to ma'am.
No, there are no I've not come across any statistics, but there are complaints where even men do have concerns of sexual harassment, but they are very few. I think the complaints which women have of sexual harassment, they are higher in number than that of males. Yes, if so, there is an appeal process. They can go to the tribunal or they can go to the appellate authority. The appellate authority, in case of companies, etc., they are the industrial courts. If it is a school, then it will be the school tribunal. So there is an appellate authority, and if the person wants to go in appeal, that person can surely can. And if there is some discrepancy in the process or then a person can also file a writ petition before the High Court. Yeah, no question. Which organization? All the organizations, all the companies, more than 10 employees have to have an IC. So let it be a software company, let it be a factory, let it be a manufacturing unit, any organization with more than 10 employees, they have to have an IC. Further provision for safeguarding the transgender and male, so far it's not implemented. What will happen in such a case? So that's why I said that it's good to have a policy in place for organizations to have a policy, because the law right now it's only sexual harassment of women at workplace. Only an aggrieved woman can file a complaint. So in order for them to safeguard men or transgender, so you can have a policy in place of the organization which will ensure that all the employees or everybody will be protected against sexual harassment. I've personally not heard of an IC being formed in small organization. So can an employer being forced to form one? Yes. Though it's not in practice that smaller companies or smaller organizations, they do not have an IC in place, but by law, it is you have to have an IC. More than 10 employees on roll, you have to have an IC. Yes, can an IC member get re-elected or reselected immediately after completing the provided term? Yes, in certain cases, yes, but it's always good to have new members on board, so that there is no biasness in in the committee. If a if the complaint is from a group of female employees, then what will be the procedure? So they can give a complaint in writing. So each of the female employees will have to give a complaint in writing, and they will be collectively heard to address this. Either they'll be collectively heard, or either they'll be heard. Either different inquiries will go. But if it is against the same respondent, then it will be collectively heard, because I think that will be the proper way to go forward. Organizations with more than 10 employees but no female employees, do we still need to have an IC? Yes, you have to have an IC, even if you do not have many. Again, now the law is gray in this area, but you can take it from a sister concern, the presiding officer. Then you can have the external member as a female who's a woman. then, so that the 50% is taken care of. What includes women at workplace? Does it include the visiting women also? Yes, that's what I spoke in the aggrieved women, right? So it can be other professional relationships. So it's not restricted only to women who are employed. To what extent the protection can be given to the victim who have complained? So interim measures can be passed, but that also has to be at the instance of the woman. But sometimes if the IC feels that they can, communicate that to the woman. But sometimes if the IC feels that some measures need to be taken, they can be taken. Maybe I can write back to you all through Law Cure. If Law Cure, you all can take the question.
All the other questions would be, they can directly write it to our email ID. We will forward them to ma'am, and ma'am can reply us with the answers.
Yes.
So with this, now we are bringing an end to this wonderful session. It has been a great session today, and we have all learned about new aspects, and we have found new perspective with regards to this subject. We here at Law Cure would like to thank Divya ma'am for taking out time and conducting this guest lecture with us, and also to all the participants who have showcased their keen interest and have been joining this session today. Before we take your humble leave, we would all actually request you to fill the feedback form so that we can bring you more exciting and more such quality sessions. Stay tuned with us for more upcoming events and webinars. Thank you, ma'am. Thank you, one and all, for joining us today.
Thank you. Thank you so much. Yeah. Bye.
Bye, ma'am. All the participants are please requested to kindly fill the feedback form before exiting the meeting.